Hope for the best, but plan for the worst. Founder relationships don't always survive a company reaching a sale or an IPO. So for that reason, even from day one, founders should consider founder vesting or reverse vesting arrangements to protect themselves and the company in the event of another founder leaving. Does a company need a co-founder agreement? Is a question we're often asked. And the answer is not necessarily. But even if the company doesn't put a formal written agreement in place, it's important that the founders have a frank and honest conversation about their expectations for each other over the course of the business. What will their time commitments be? What will their responsibilities be? What do they expect from themselves? And what do they expect from each other? But what if things don't work out and for one reason or another, one of the founders wants to walk away? Well, there's two key questions which the founders need to consider, at least in their discussions with each other. First, what should happen to a departing founder's shares? And second, what should happen to the departing founder's board seats and other governance and information rights? So what should happen to a departing founder's shares? And the key question really is, do they get to keep their shares or not? If they do get to keep their shares, this might be because they've been with the company for a certain period of time and you might have agreed that some of the shares have vested. But even if a founder gets to keep their shares, you might want to consider whether the remaining founder could get a power of attorney over those shares, or if a nominee agreement would be put in place over those shares. Because the departed founder, because they won't be involved in the day-to-day running of the company, it's important that the remaining founders are easily able to pass resolutions that a departing founder cannot block. Or, if a departing founder should lose some of their shares, or lose all of their shares, the question is, should they be just simply lost, or should the departing founder get some cash for those shares? Now, the legal agreements might say that the founder would get fair value for those shares, and determining fair value, particularly at an earlier stage, can be a difficult and complicated process. One thing, though, that all founders should be aware of is that company law imposes restrictions on companies buying back their own shares. So while it's possible, you may need to take some further corporate action, and you should speak to your accountant and your lawyer before deciding on a valuation. And finally, what should happen to a departing founder's board seat and other information rights? A departing founder will naturally want to keep their board seat because this gives them oversight into the day-to-day running of the company. And in the early days of a company, this might be acceptable. But in later stage companies which have taken more investment, have investor directors and non-executive directors on the board, and ask for a founder to remain on the board is significantly more challenging and maybe not something that the company wants to give as easily. But for more information and expert advice on vesting, reverse vesting, levers and bad levers, contact me or another member of the corporate team.